Welcome to the Divorce Lawyers podcast, brought to you by DivorceLawyers.ca. In this episode, we'll be discussing a topic that often brings anxiety and uncertainty to many going through a separation: what to expect during divorce trials. Divorce trials can be daunting. For many, they represent the culmination of months, if not years, of emotional and legal battles. Today, we're going to explore what you can expect if your case heads to trial, covering everything from the initial stages of preparation to the final judgment. By the end of this episode, you'll have a clearer understanding of the process and how to best prepare yourself. Let's dive in. First, it's important to note that the majority of divorce cases don't actually go to trial. Statistics show that only around 3% of cases end up before a judge. Most are resolved through negotiation, mediation, or other forms of dispute resolution. However, when those methods fail, a trial becomes necessary. Divorce trials can be long, complex, and expensive. They often take a significant emotional toll on everyone involved, but sometimes they are the only way to achieve a fair outcome. This is especially true when the stakes are high, such as disputes over child custody, property division, or spousal support. The key to navigating a divorce trial is preparation. From the moment you meet with your lawyer, trial preparation begins. Even if you hope to settle, your lawyer will start planning for the possibility of a trial. This involves gathering evidence, identifying potential witnesses, and strategizing how to present your case effectively. One of the first things your lawyer will do is prepare a draft order, a document outlining everything you're seeking from the court. This serves as a roadmap for the trial and helps guide your lawyer's strategy throughout the process. Your role in this preparation is crucial. You need to be actively involved by providing all the necessary documents, meeting with your lawyer regularly, and being open to their advice. Remember, your lawyer is there to help you navigate the legal system and present your case in the best possible light. Now let's move on to what actually happens during a divorce trial. Unlike the quick resolutions you might see on TV, trials can last several days, sometimes even weeks, depending on the complexity of the issues at hand. The trial typically begins with opening statements. Both parties have the opportunity to present an opening statement where your lawyer will outline your case, set the stage for the evidence to come, and provide the judge with an overview of what to expect. Next comes the presentation of evidence, which forms the core of the trial. Both sides present their evidence, which could include documents, financial records, and witness testimony. Evidence comes in two primary forms: oral testimony, where witnesses speak directly in court, and written testimony, often in the form of affidavits that support or challenge the spoken evidence. Following this is the cross-examination. After a witness testifies, the opposing lawyer has the opportunity to question them. This part of the trial can be particularly intense, as it can challenge the credibility of the witness and the strength of their testimony. Once all the evidence is presented, both sides make their closing arguments. This is where your lawyer will summarize the case, highlight key pieces of evidence, and argue why the judge should rule in your favor. Throughout the trial, the judge isn't just listening to the facts being presented. They're also observing the demeanor of the witnesses, the consistency of their testimony, and even how they respond under pressure. These observations can play a significant role in how the judge ultimately decides the case. Your behavior in court matters just as much as the evidence. Courts are formal environments, and judges expect a certain level of respect and decorum. How you present yourself, both in appearance and in how you conduct yourself, can influence the judge's perception of your credibility. You should dress as you would for an important business meeting. It's important to be respectful, but also comfortable, since trials can last for long hours. You don't want to be distracted by an uncomfortable outfit. Remember, you're not just a spectator in your own trial. You're an active participant. Your demeanor is also important. Judges are human, and they notice body language, tone of voice, and emotional reactions. If you become overly emotional or confrontational, it could work against you. It's crucial to stay calm and composed, even if the opposing side's testimony is upsetting or misleading. Once the trial concludes, there's often a period of waiting before you receive the judge's decision. This can take several weeks, sometimes even months. During this time, the judge will review all the evidence, consider the arguments, and apply the law to the facts of your case, When the decision is made, it will be delivered in writing. The written judgment will explain the judge's reasoning, the law they applied, and the final orders they are making. It's essential to read this document carefully and discuss it with your lawyer, especially if you're considering an appeal. Speaking of appeals, if you're unhappy with the judge's decision, you do have the option to appeal. However, appeals are not easy and are rarely successful unless there was a clear error in law or procedure. Before pursuing an appeal, weigh the costs and benefits carefully with your lawyer. One common question is whether you'll get your legal fees covered if you win. The answer is, it depends. In family law, the awarding of legal costs is at the discretion of the judge. Typically, the winning party may be awarded some of their legal costs, but it's rare to recover 100% of your fees. Judges consider several factors when awarding costs, including the behavior of both parties during the litigation. If one party has acted in bad faith, been uncooperative, or caused unnecessary delays, they may be ordered to pay a larger share of the legal fees. Divorce trials are challenging and often stressful, but understanding what to expect can help you navigate the process more effectively. Preparation is crucial. Work closely with your lawyer, present your case clearly, and stay composed throughout the trial. While trials are a last resort, sometimes they're necessary to achieve a fair outcome. Thank you for joining me on this episode of the Divorce Lawyers podcast. If you have any questions or need legal assistance, don't hesitate to reach out to us at DivorceLawyers.ca. We're here to help you every step of the way. Until next time, stay informed and take care.